The Honourable Minister of State for Western Diversification.
Well, thank you, Mr. Speaker. What was just set aside, there's something that I actually think has not been adequately debated in this House, and that's the using the statement, "What two consenting adults do between them is not the state's concern," as an underpinning to argue that that the asymmetrical criminalization which has been put forward through this bill is not an adequate response to the Bedford ruling. And that's because at the heart of this statement is the concept of sexual consent. Our criminal code provides a standard definition for sex without consent under Section 273.1. Some of the provisions, of course, include that agreement is expressed by words or conduct of a person other than the complainant. The complainant is incapable of consenting to the activity. There's other provisions. And through case law, we've seen that a sexual assault offense is established by proof of three elements: touching, the sexual nature of the content, and the absence of consent. Furthermore, case law has shown that the absence of consent is subjective by reference to the complainant's internal state of mind towards the touching at the time it occurred. But beyond this criminal definition of sexual consent is the work that groups involved with prevention of sexual assault have been doing to educate the public on the relationship between knowing and celebrating one's sexuality in order to define the boundaries of consent. I had a transformational moment last week when I had a chance to speak with Elspeth Mayer of the YWCA of Calgary, and I asked her, I said, well, what do you define as sexual consent? And she talked about an enthusiastic response that's exhibited by both parties. And I'm also very proud of the work of the University of Calgary's Consent Awareness and Sexual Education Club. They ran a Consent is Sweet campaign to bring this more accurate, in my opinion, concept of sexual consent to their student body. Since time immemorial, Mr. Speaker, empowered, educated, enthusiastic sexuality, particularly female sexuality, has been written into literature, social mores, and religious practice as an evil, something to be avoided for fear of ripping the very fabric of society. And it's only been in very recent decades that Western culture, particularly through the feminist movement, has enshrined a new view of consent into our consciousness. And yet we still struggle to protect this. From rapey chants at Frosh Weeks to requests for female airport security officers to be segregated, we still as a culture are challenged with the full acceptance of empowered, equitable sexuality. Furthermore, at the heart of this new notion of sexual consent is the concept of equality, that all parties are in equilibrium from a power dynamic perspective. As such, I feel that the what two consenting adults do argument is flawed, as there is an overwhelming burden of proof that a large majority of sex workers are not in an equitable position. Be it a young worker who entered into the trade before having an opportunity to define what an enthusiastic response means in terms of their own sexuality, workers who are selling out of desperation, that can't make the rent, they're supporting substance abuse to support their children, or any other determinant of poverty, or workers who are suffering from mental health issues. There is not equality in the power balance between the parties, and as such, in most situations, I would argue that true sexual consent, this enthusiasm that Elspeth speaks about, what we're striving for as a culture to enshrine, is difficult to achieve in most sex trade transactions. And in demonstrating this, several studies based on surveys or anecdotal evidence from sex worker advocates and service providers suggest that the prevalence of sexual assault in the sex industry is high, particularly in the case of street-level workers. There's a 2005 Vancouver study which showed that 78%, or said that 78% of these workers had been raped in prostitution. Studies that had been carried out in the mid-90s by the Department of Justice showed that physical and sexual assaults on prostitutes were commonly carried out by clients, pimps, or boyfriends. And in 2003, the Australian Centre for the Study of Sexual Assault published a briefing entitled "What Lies Behind the Hidden Figure of Sexual Assault? Issues of Prevalence and Disclosure," in which the notion that women working in the sex industry are at a greater risk of sexual violence. The paper also briefly provides information about the treatment of sex workers in the courts and the judiciary in sexual assault cases. We know that sexual assault is underreported in general, and that, I believe, is even more so, Mr. Speaker, in the case of sex workers. Some of the issues that are raised in response to why sex workers do not report sexual assault is that they're afraid of being charged with prostitution-related offense as a result of making the statement. And they also indicate that being exposed as a sex worker to friends and families is another reason to not report the incident to the police. And, Mr. Speaker, when you look at case law, defense strategies generally consist of attacking the credibility of the victim. I looked at some case law that, involving sexual assault prostitutes from 2004 to 2014. Here are some of the defense strategies. The complainant consented on previous and future occasions. The complainant is a drug addict, was under the influence when the sexual activities took place, suffers from depression, or cannot recollect the events due to memory lapses. And the complainant continued to work as a prostitute for many years after the event. Therefore, she consented to the activity and was not traumatized. I ask, Mr. Speaker, how do these defenses demonstrate our culture's acceptance of the value of full, enthusiastic, empowered sexual consent? In research completed for me by the Library of Parliament, several court cases showed the difficulty of defining consent in the context of casework. R versus House, R versus Dick, R versus Lumsden, and R versus Jakir. The courts noticed that sex workers are particularly vulnerable and are entitled to the full measure of protection of the law as of any other person. And the review of cases tended to show that there is no general trend of the judicial interpretation of consent by sex workers. In this context, it seemed like the consent of prostitutes is determined by the courts on a case-by-case basis. Mr. Speaker, how much time do I have? I'd like to read part of a ruling from the Ontario Court of Justice in relation to sexual assault with a sex worker. In the circumstances of this case, although I'm prepared to accept that she may have had grave misgivings and was in fact not consenting, her words and actions were such that a reasonable person might have honest but mistaken belief to her consent. When she got in the car, asked for the money agreed upon, and then apparently willingly complied to the sexual requests of these young men, I do not agree that the Crown's submission that the young man had any obligation to ask her if she was consenting to sexual contact when she entered the car. It was reasonable for them to assume that she was consenting when she met with them a request for the $30 fee before engaging in sexual activity, and never, by word or action, indicated that she was not consenting to continue. Surely it is not the law that a client of a prostitute has to continually ask whether the acts engaged are consensual. I wish I had more time to read this whole ruling, Mr. Speaker, because given rulings like this, websites which rate sex workers include comments like, "She didn't look at me when we were doing it. She cried a bit halfway through." I'm not of the view that any person has a God-given right to access the purchase of sex, or that the purchase of sex should in and of itself define sexual consent. To protect sex workers in this country, we need to stop and acknowledge that this is a fundamental flaw in any argument for the legalization of prostitution. By legalizing prostitution, we would only degrade a hard-fought cultural understanding of the worth of humans and our sexuality, and make it harder for the victims of sexual assault, even those that are sex workers, to seek recompense and heal. This is not to say, however, that sex workers are in every instance incapable of giving consent. By contrast, by adopting this bill, C-36, and related funding that we've announced, our country acknowledges that, yes, we have the right to consent over what we choose to do with our bodies, but that the burden of proof is overwhelming and shows that the majority of sex workers are degraded, assaulted, and abused, and as such, we as a society and as a nature recognize that the purchase of sexual services is an action in which we believe our nation is criminal. Mr. Speaker, in the committee hearings, one of the witnesses spoke to the asymmetrical provisions and said, "Where is it that you can just purchase something legally but not buy it legally? Why don't we do that with booze?" Well, Mr. Speaker, a bottle of booze is not a human being. And I do believe that in order for us to show that we as a country have moved beyond a very limited range of sexual consent, and that we as a culture show an empowered and believe in an empowered, willing, enthusiastic sexual consent definition, that this law needs to be adopted. Thank you, Mr. Speaker.
Question commenté l'honorable député de Gatineau.
Monsieur le Président, je remercie la collègue d'en face. J'aimerais peut-être juste avoir quelques réponses à des questions très précises. D'une part, savoir si, dans l'optique de la députée, ce qu'on a devant nous, c'est une façon de rendre illégale la prostitution. Est-ce que la prostitution est illégale au Canada? Si la réponse est oui, ça lui évitera de continuer la question. Si la réponse est non, sans faire de comparaison, je ne fais pas de comparaison avec l'alcool, mais j'essaye encore à ce jour de comprendre comment le geste d'acheter peut être criminel, mais le geste de vendre ne l'est pas. Et en quoi les dispositions actuelles du Code criminel sur la traite des personnes, sur le fait d'exploiter, qui existe toujours sans les 3 petites clauses en question qui ont été traitées par la Cour suprême du Canada, si la police n'a pas été capable de faire le travail au niveau de l'exploitation des femmes qui sont dans ce milieu-là sans consentement, qu'est-ce qui fait que la députée pense que les travailleurs de sexe vont être plus en sécurité avec leur projet de loi C-36? Et si elle est d'accord avec le 20 millions qui a été conclu par tout le monde comme étant d'un ridicule total?
The Honourable Minister of State.
Thank you, Mr. Speaker. I actually thank my colleague for this question because I think it's at the heart of this debate. You know, how can that asymmetry protect sex workers, and why have we approached it? And it's as simple as this. Mr. Speaker, the criminal code in Canada is a statement on which what we believe in this country is acceptable in terms of behavior and what we think is criminal. Mr. Speaker, given the burden of proof that shows that sex workers are subjected, for the most part, to abuse, to sexual assault, etc., we're acknowledging that the purchase of sexual services is a determinant to seeing that outcome that we don't want to happen. Therefore, we are putting that into law. We are saying as a country that we acknowledge that that particular action, the purchase of sexual services, is not acceptable and is a determinant to causing abuse, Mr. Speaker. On the other hand, we still acknowledge that humans have a right to choose what they will do with their body, and through social programming, support people exiting the trade.
Questions and comments? The Honourable Member for Charlottetown.
Thank you, Mr. Speaker, and I thank the Minister for her speech. One of the things that she said was that an impediment to those involved in the sex trade from reporting sexual assaults is the fear of being charged with a prostitution-related offence. This bill doesn't fix that. Those involved in the sex trade are still subject to criminal prosecution and to a criminal record for communicating in certain circumstances. So given that that is one of the concerns that she has, would she agree with all of the evidence we heard at committee with respect to the criminalization of those in the trade? And I would also repeat the question offered by the member from Gatineau with respect to the adequacy of the $20 million that's been set aside for exit programs, her views on that. Thank you.
The Honourable Minister of State.
Well, Mr. Speaker, again, the point I was trying to make with my speech and showing that sex workers have difficulty, we both have difficulty in getting sex workers to report instances of sexual assault and then convictions, is by, we need to say that there is an issue in obtaining consent in a sex trade transaction, Mr. Speaker. Boundaries can be broken quite easily, and then the person who's being assaulted is in the position of trying to show the burden of proof that this did occur. And I think, Mr. Speaker, by saying that we do not, as a country, support the purchase of sexual services, we are actually going to say that this is illegal. We are actually going to help raise an awareness that sexual assault does occur in this situation, and that was really the point I was trying to make in my speech. With regard to social programming, I fully believe that in order to assist sex workers who find themselves in the trade out of desperation or out of poverty, yes, certainly we have an onus as parliamentarians to ensure that there is adequate programmings available. Mr. Speaker, it's not just about the $20 million. It's also about the myriad of other support services that we fund through government, Mr. Speaker. We've increased transfer payments to the provinces for education, for health care to record levels, Mr. Speaker. We have all sorts of different employment services. I could speak just at length to that. Do we need to ensure that those are adequate and working? Yes.